Hi, this is Steve Dale, and we're doing a very special program today, a program called Keep the Lanterman Promise. My co host here, Pat Hornbecker, will be giving us a little bit more information about the KTLP program, the history, and that sort of thing here. But this is a program that's been around for what, 20 years that I know of. And this all has to do with providing services for persons in California under our civil rights program, which is called the Lanterman Act. Okay. Now, for those of you that are watching, this program has been approved for MCLE credit by the State Bar of California, by the North Bay Housing Coalition, provider number 14598. Once again, in order to get credit, there'll be 3 codes that you're going to need to record, and then you need to fill it out, fill out the MCLE credit form in order to receive credit. And this should be good for attorneys and fiduciaries. Okay. Also, with that, we're hoping that you'll sign up for our mailing list for future programs. So let me go into a little bit about what this is all about. Okay. So this is a 3-part series here. And what we're doing today is part 1, and that's really the core of the program, of this program that we call Keep the Lanterman Promise series, or KTLP. Today is part 1, which is focused on the history of the Lanterman Act, followed by the IPP and the IPP process. This will be followed by a program on information and advocacy programs, and then that'll be followed by another program on service organizations. The main focus of the KTLP program is the importance of the Lanterman Act for securing essential services for persons with intellectual and developmental disabilities living in the community. Okay, now our audience for this is pretty broad. I would say it's everybody here. Now, each of these programs will focus on a series of interviews of key players and key programs that are necessary to fulfill the promise of the Lanterman Act. Each of these interviews was designed to stand on their own, and so they can be used by advocates and professionals as resources for sharing in their community the important concepts and resources we're going to be talking about. For professionals that are watching this program for credit, consider this. If you're creating a special needs trust or administering a special needs trust for a client or a beneficiary that has a loved one with an intellectual or developmental disability in California, how can you create a plan or execute that plan to supplement the client's loved one's needs if you don't understand the services or systems that you're supplementing? So for families that are watching this program that are looking to hire a trustee or an attorney here to create or administer a special needs trust for a loved one with an intellectual or developmental disability, doesn't it seem important that your professional understand California's system of supports under the Lanterman Act to ensure that the plan is relevant for your loved one's needs? You know, as I like to say, if your attorney or trustee doesn't know the difference between an IPP and an SUV, you might want to consider engaging a different professional. As we're going to learn, the Lanterman Act and the IPP process itself is key to just about everything. So I want to introduce my co-host here for this series, Pat Hornbecker, who's the president of the board of the ARC of California here, and so many other things, quite frankly, that you can get into more than I can. And we've probably known each other for at least 30 years, maybe
at least, longer. But we don't count anymore.
We don't count any longer. So anyway, Pat, thank you for joining us today. And what are your thoughts about the Lanterman Act?
Well, it's my pleasure to be here. I'm a parent, and I was back here at the beginning of this creation of the the KTLP, Keep the Lanterman Promise, which was the brainchild of 2 executive directors of 2 chapters of the ARC of California. Jim Stream was the executive director of Riverside, and Barbara Mazie was the executive director of the ARC of Contra Costa County. And the two of them thought that we should put together a program that gave the history of the Lanterman Act, as well as the nuts and bolts about how you can move through the system and understand it and be successful and write a proper IPP. But that when there were barriers or roadblocks, you knew what to do and who to call in order to make the system work for you. The Lanterman Act, as Steve said, is at the heart of the California DDS system. It's our center and key to any successful advocacy. Our presentation today will give you an historical perspective, which is important because we are the only state in this country that has an entitlement to services for people with developmental disabilities. And that cannot be stressed enough, as Chad, our next speaker, will be telling you. The history is important because of the uniqueness, but we also need to understand that once you get into the system, you need to understand all of the nuts and bolts that come with it. And that will be a second presentation. So let's get going.
Thank you, Steve. It's nice to be here today. Thank you all for joining me today. My name is Chad Carlock. I'm an attorney who's been working with families and service providers in the developmental disabilities area for over 25 years. And I want to talk to you today about the history of the Lanterman Act and why California's legislation, the Lanterman Act, and the entitlement that was created by the Lanterman Act are so important, have been so important in the development of the service industry in California, and why it's so important and why the knowledge of where it came from and how it came to be the way it is important for us to protect the entitlement in the future. I want to start by going back to the beginning of the service system in California. For a long time, there was no service system in California. Families were basically on their own. Communities were on their own. Some communities, some families started banding together to create their own resources, sort of from the ground up. That's where the ARC came from. Groups of families getting together to provide support to each other and to create programs and services for their family members. That's where basically the impetus for the special education system in California education came from, was a parent up, grassroots type of thing. But in terms of state provided services and facilities, until really the 50s and 60s, the only thing that was available was the state hospitals, as they were originally called, which were institutional, large institutional segregated facilities where people with disabilities were cared for, but were essentially warehoused and were cut off from the greater community and given the services and supports that they needed to stay alive, but not to thrive. So the state hospitals were really the only option for families in terms of public supports during the first part of the 20th century, for sure, and until the rise of the community-based service system that was created by the Lanterman Act. So before that, essentially the only options were staying at home with your family members and having family members or community or siblings care for people with disabilities, or shipping them off to the state hospitals. They were few and far between, so oftentimes this was a long trip and was very isolating for the rest of the family. If they had a person with a disabilities that was sent to an institution, they may or may not have ever even seen that person again, in fact. So many families and parents got together and started networking, as I said, in the late 40s, 50s, and into the 60s to form these collective organizations like the ARC, like other service provider organizations that eventually developed later on, and other advocacy organizations, including consumer-led advocacy organizations that developed over time. But originally, the idea for this was for parents to work together and strategize and get grassroots support for alternatives to these state-run, state-operated institutions. This was happening all across the country. So it was happening here in California, it was happening in other states, and it was happening at the federal level. In the early 60s, the Kennedy administration, in fact, started taking a look at services and what has been available and what should be available to people with disabilities and their families. So there was a presidential panel that was convened in 1961, provided a report and recommendations to the federal government in 1963. So it developed some new legal resources and legal mechanisms for additional services and supports to be provided at the federal level. President Kennedy, in fact, in October 24th of 1963, addressed the National Convention of the ARC and talked about the development of additional services and supports and the community-based services and supports. At the same time, 1963 in California, there were 13,500 individuals who were residing in the state institutions at that time. And there were 4,000 more who were on the waiting list to get in to the state hospitals, as they were still called at that point. There was some family involvement in the institutions. And in fact, the Fairview State Hospital was visited by some parents and community advocates, and they brought along an investigative reporter with them to take a look at what the conditions were and what kind of services were provided in the state hospitals. The reporter reported in their series of scathing articles that it was the worst conditions they have ever seen in a facility, in a series of reports that they did. The San Francisco Chronicle also did a investigative series looking at the state hospitals, including the Sonoma State Hospital at that time, which was a series of large, even in 1963, aging and old warehouse, type facilities. They brought in an expert in the field from Denmark who viewed the Sonoma State Hospital, and he said, in our country, we would not treat cattle like these people are being treated in the Sonoma State Hospital. So the advocates visited. There was some public attention and bad press, of course, for the state as a result of these two investigative journalism series. And there was some heat on the state legislature. What should be done about the state hospitals, the condition of the state hospitals, the fact that there was a wait list to get into the state hospitals, and what sorts of services were being provided. At this time in the early 60s, Governor Pat Brown, father of Governor Jerry Brown, was governor of California at the time. And so he went to the legislature for answers, asked them to study the situation and propose solutions. What should the state do about this situation? The State Department that was overseeing the state hospitals at that point was still called the Department of Mental Hygiene. So they did an internal study and proposed to the legislature that the solution to the state hospital problem was to build more state hospitals. They also decided they should be rebranded the developmental centers to sort of modernize the language a little bit, at least. But their solution was, well, let's build more so we can have modern facilities and get people off the wait list and continue to provide services in these state institutions for more people with developmental disabilities. And some of the legislators pushed back on that, including Frank Lanterman and his two co-sponsors of what became the Lanterman Act. They posed the novel question of maybe we should ask what the parents want in terms of services going forward. Parents answered, the ARC and other advocacy groups went to these hearings and testified, and that they said they wanted a life with value for their loved ones. Not a warehouse, not an institution, not a segregated setting, but a new model, the community-based model. So the legislature decided that this new model was worth trying out. And in 1966, legislation was passed that created two pilot programs for the first two, what became known as regional centers. So this is before the Lanterman Act, in fact, came in. It was, as I said, 2 pilot programs, regional to San Francisco and Los Angeles. The idea at that point was that those 2 pilot programs would review the waiting lists, take a look at who was on them, what their needs were, and develop some alternatives to assist families at home while they were waiting to get into the institutions. What other services could be provided? Initially, these services were mostly medical supports, physical therapy for those with physical disabilities, and hope that eventually there will be space for your loved one in an institution. The parents continued to network. They were forming their own groups. They were advocating, and they were, again, looking for a different model. They started their own schools, private schools, outside of the public school system, and they also advocated for and eventually were able to get the adoption of the special ed program across the state. Now, after these 2 pilot programs were developed and in the running for a few years, eventually these pilot programs and a lot of advocacy by parents and parental groups and advocacy groups and self-advocates resulted in the signing of the Lanterman Act. The Lanterman Act was enacted in 1969. Fun story, a little background on the actual creation of the Lanterman Act. Mr. Lanterman had developed the legislation, working with families and developing this wider model for how we're going to expand services across the state outside of the developmental centers, and even as an alternative to the developmental centers, working closely with parents. But it was an uphill battle in the legislature. And there was a lot of times when it looked like the Lanterman Act might fall by the wayside or get delayed or watered down or not passed at all. And there's a famous story about a group of parents, I think it was mostly mothers, but a group of parents who followed Mr. Lanterman across the street from the state capitol to the Senator Hotel, where many legislators lived during the legislative season, and literally cornered him in an elevator and talked to him about the needs of their families and the importance of these reforms that were being proposed in what became the Lanterman Act. As a direct result of this parental advocacy, he became the champion of the Lanterman Act. That's how it ended up with his name. And he ensured that the needs of these families were not going to be overlooked and that the legislation would, in fact, be passed. The Lanterman Act was signed into law in 1969 by, at the time, California Governor Ronald Reagan. And so Senator Short and Lanterman and several other legislators were key to making sure that this act got passed. It expanded the regional center system statewide. That continued to develop over time, but it established a framework for services for people with intellectual and developmental disabilities. There was a major revision of the 1969 Act in 1973 that expanded it even further. The 1973 legislation created eligibility categories, not just mental retardation, but autism, cerebral palsy, epilepsy, and what's become known as the 5th category, which is other neurologically handicapping conditions that are similar to those other categories. So it greatly expanded the scope of eligibility for services, and it also created in 1977 in another amendment expanding on the scope of the Lanterman Act, it created the Department of Developmental Services as its own distinct entity, a state agency created to oversee the operations and the funding of all the regional centers and the developmental centers. Over time, the regional center system has grown from the original 2 pilot programs in San Francisco and Los Angeles to the current 21 regional centers set up all over the state. Because of population, primarily, 8 of those 21 are located inside Los Angeles County. So the other 13 cover the rest of the state. The Bay Area has 7 regional centers. And then there are some rural areas where multiple counties, I think up to 10 counties up in the northeast corner of the state, are all covered by one regional center. So the idea was that they would all be roughly equivalent in population. Once upon a time, that was true, but the system of regional centers has not changed. It has not continued to expand. It's sort of locked in right now at 21. So there are some real differences in populations that are served by each regional center. Obviously, there are also geographic differences in regional centers, like Central Valley or Kern Regional Center or Inland Regional Center, and Far Northern Regional Center up in the far north, as it goes by its name. There are additional challenges that come from just the geographic spread of the regional center. There are transportation issues that come in, and the availability of programs varies widely from one regional center to the next. In a small urban regional center, you may have to go 10 miles to reach your nearest program, whereas in the high desert, it might be 100 miles that you have to travel to get to a program that can meet your needs. So there are geographic issues and other issues between the different regional centers. But the idea is, and the purpose behind the regional center system, is that ideally you have a localized authority that can respond to those localized needs and can adapt to them and help develop programs and help consumers and families find programs within their geographic area that can meet their needs. Now, these regional centers were established as local nonprofit agencies. They're not government agencies most of the time. They end up performing sort of quasi-government functions because they are the conduits between the state of California and the funding sources and the service providers and families on the other end of the system. They're operated and overseen by community-based boards of directors. The idea originally was one regional center per million population, but now, as I just mentioned, we have 21 regional centers and approaching 50 million people in the state of California. I haven't heard anybody advocating or clamoring for getting us up to 50 regional centers anytime soon. So I think we're stuck with the 21 probably for the foreseeable future. But one of the things that we're going to talk about later is that that could always be changed by the legislature. They could add regional centers. They could take away regional centers. They could do away with the regional centers and directly administer the programs. So, just because it's in the Lanterman Act now doesn't mean it always will be. Each regional center has a contract with the Department of Developmental Services. They have performance goals that they're supposed to meet. They have data reporting that they have to send back to the department. And if the regional center is not performing their obligations, the Department of Developmental Services can step in and either operate the regional center directly or terminate that contract and contract with a new board to run a new regional center for the same area. Regional centers' responsibilities generally are for intake, new consumers coming into the system, making sure they're eligible, managing their cases, meaning conducting the IPP meetings, making sure that the client's needs are assessed and that there's a determination made as to what services will meet those needs, and then finding the vendors and contracting with the vendors who are going to provide those services. They also then oversee quality assurance to make sure that the service providers that are contracted with are actually meeting the consumer's needs and helping them to survive and thrive, hopefully, in the community. So the regional center system developed, throughout the 70s as a result of the Lanterman Act being enacted in 1969 and revised throughout the 70s and 75, again in 77. The next big milestone in the development of the Lanterman Act came from the 1982 state recession in California. There was an economic downturn throughout the country, and especially in California in 1982. The state government had an $11 million deficit. Now, that in today's budgets, that's a rounding error, but in 1982, that was real money. And this was statewide, not just the developmental services budget, but the entire state budget had an $11 million deficit that they were looking to close. One of the ways in which they sought to close that budget deficit was ordering cuts to the DDS budget. Now that cut to the DDS budget was unallocated, so it was up to the department to figure out where to get the money from. The Department of Developmental Services issued a set of spending priorities to the regional center. Now, priorities was a euphemism for limits, and what it in fact did was directed the regional centers, in order to save money, you are only permitted to purchase for your consumers a place to live, a day program, and whatever else you need to ensure their basic health and safety. No bells or whistles, no frills, no additional services, no additional supports beyond those three categories. And a group of families through the Arc of California sued the state to stop these funding priorities from going into effect. That lawsuit was filed in 1982 by a group of families, and again led by the Arc of California. Eventually, that litigation made its way all the way to the California Supreme Court. The trial court in that case in 1982 ruled in favor of the parents and issued an injunction to stop those spending priorities from going into effect. So the state appealed that decision, and the Court of Appeals also ruled in favor of the parents and left the injunction in place. So the state appealed again to the California Supreme Court. That's why it took 3 years for the case being filed in 1982 to making it to the California Supreme Court in 1985. It ended up being a unanimous decision by the California Supreme Court, and they affirmed the vote below. They agreed again and affirmed the lower court's decision granting injunctive relief and prohibiting the state from implementing those spending priorities. Now, so this 1985 Supreme Court case really is the most important case in terms of the entitlement, at least, in the history of the interpretation of the Lanterman Act, and not just because they ruled in favor of the parents, but because of what the court said in doing so. It was, as I said, a unanimous 7-0 verdict in favor of the parents. And the court held for the first time that what the Lanterman Act had done in 1969 was created an entitlement, a statutory entitlement for all people with intellectual and developmental disabilities in California to receive the services that they need and to receive those services at the state's expense. So this was, it's been called sometimes the creation of the entitlement, but that is a bit of a misnomer because that assumes that the entitlement did not exist before 1985. And that's not what the California Supreme Court said. What they said was that although it had never been recognized as such before, the entitlements started in 1969 with the passage of the Lanterman Act. And that in fact, when the legislature said that the state of California assumes an obligation for our citizens with intellectual and developmental disabilities, which we must follow, that's what they meant. The entitlement really is an entitlement. The driver of the system, the determination of the scope of the entitlement, is not the amount of funding that is allocated by the state. It's the individual consumer's IPP, their individual program plan. If you aggregate all of those together, whatever is required to provide those services, that is what the entitlement requires. One of the things that the department had argued in that case was that A, there's no entitlement, And B, if there is an entitlement, the scope of the entitlement should be limited to the amount of money that we allocate to carry it out. And once we run out of money, that's the end of the entitlement. And the California Supreme Court said, no, the entitlement is the entitlement, and the state is obligated to provide services for everyone with an IPP to the greatest extent possible. We'll talk about in a minute what happens when the money runs out. What they said the department could not do was to alter the scope of the entitlement, to narrow or reduce the entitlement by issuing administrative priorities, or by saying you can only spend money on X and Y and not Z. Those sorts of things the court called categorical reductions. And basically they're saying, but you're administratively changing the law without actually changing the law. So what the Supreme Court held was the only way to change the law is for the legislature to actually change the law, to change the scope of the entitlement, to say that specifically the entitlement allows for these types of services and not other types of services. But that's not what the Lanterman Act says. And so the Supreme Court said that's not what you can do by limiting your funding or limiting the categories of services that can be provided. And I'm going to give you a couple quotes just to underscore how revolutionary this was, how important it was, and how important it still is in the scope of services today and looking at what the scope of services is going to look like in the future. In talking about the entitlement, the California Supreme Court said, quote, the act clearly defines the right of the developmentally disabled person to be provided with services and the corresponding obligation of the state to provide them. In talking about the IPP process, the court said it is through the IPP procedure that the right the act grants to each developmentally disabled person and the obligation it imposes on the state are implemented. So the content of the entitlement really is an individual right of each person with a developmental disability to receive the services that they need as defined by their IPP document. That's why it's so important to make sure that all the needs, all the wants, all the goals, all the objectives, and all the services that an individual wants and needs are contained within that document. The court talked about the role of the regional centers in implementing the entitlement. And the court said, while it is true that the regional centers have wide discretion in determining how to implement the IPP, they have no discretion at all in determining whether to implement it. They must do so. So this means that the regional center is obligated contractually and through the entitlement to provide all the services that are set forth in that IPP document. Now, how those services are provided is a matter for their expertise, their advice to the consumer and family about what services are available, what providers are available, and how those needs can be met. But they have to work with the family and the individual in making decisions and making choices about how to deliver those services and how best to meet those needs. They do not have the discretion to not meet a need that is set forth in the IPP. The state does not have the ability to define the substance of what can and can't, should and shouldn't be in those IPPs. That's a matter for the planning team to decide. Now, the court did say when the money runs out, the department obviously cannot continue to fund services, indefinitely beyond what's allocated to them. But what the court said the department needs to do is to go back to the legislature. And the remedy is with the legislature. The department has an obligation to report back to the legislature. We are not able to meet all of our consumers' needs under the entitlement because we have not been granted enough resources. Then the critical decision has to be made by the legislature. Do they allocate more funds so that the entitlement can be fully realized? Or do they legislatively change the scope of the entitlement to reduce the amount of services that are being provided? They can only do so by changing the Lanterman Act. And one could argue that that's in fact what has happened over the last 20 years. There's been a series of rate freezes. There's been a series of changes made to the Lanterman Act that you could argue are in fact legislative changes that chip away at that entitlement. Things like recreation and camp services that were not available for quite an extended period of time because the legislature made changes to the Lanterman Act. Rate caps, rate freezes that prevented consumers from receiving the services that they need, that prevented providers from being able to attract and retain qualified staff and adequate staff to cover their needs and to meet the ratios and objectives that they're required to and that they needed to provide good services. So it's very important as advocates, as family members, as consumers, that we pay attention to what's going on every year in Sacramento, what the contents are of those budget trailer bills that make substantive changes to the Lanterman Act. That is the only way, according to the Supreme Court's decision, that the entitlement can be changed, altered, reduced, enlarged, or done away with completely. So when those changes are made, we need to be paying attention. We need to know that they're coming so that we can tell the legislature what sorts of impacts those changes are going to have. And if those changes are made, either over our objection or without us noticing, we have to go back and hold them accountable and say, these are the changes you made last year. This is what's happened to my family member as a result. This is what's happened to the day program that my family member went to for 20 years and is now closing their doors. So these things are important. They matter. That's why it's important to pay attention to what's going on in Sacramento. And if we want to preserve and protect the entitlement and even enlarge the scope of the entitlement, the only way to do that is through the legislature. So we have to make sure that we understand what's going on, that the legislature understands what's going on, and that parents and advocates and family members and consumers continue to have a voice in the process of recognizing, celebrating, and protecting and maintaining that entitlement. If you want to learn more about how the IPP process works, watch the next video, and I thank you for your time.
That was, to me, I've actually heard Chad talk about this several times, and it might be good to just take a moment and reflect on what we just saw. Part of this is that California is the only state with an entitlement that has an entitlement for services for persons with intellectual and developmental disabilities. On the other hand, I'll tell you, the most chilling part for me that I got out of that, Pat, is that Chad's segment that if there are insufficient funds to keep the promise, that the case here is really clear that the legislature is required to return to the legislature and modify the Lanterman Act. I mean, I've been monitoring programs across the country and even within our state. And if we really look at, how rare this is, as far as we know, this is the only system. And by the way, it's not for everybody. This doesn't affect mental health directly. Not that we don't have folks with IDD that have behavioral health issues and that kind of thing. But this is a very special thing in California. And I think the thing that's so scary is it could be lost.
They can write it out at any time. And that's why the ARC and the 21 chapters across the state work so hard to stay in touch with all of the legislators and making them understand how important it is for each of the 400,000 people in the state of California that receive these services. That is an awful lot of people. And we need to make sure that the services are available, that their rights are known. And that's why at this point in time, we really need to rally our advocates across the state to stay informed and know what could possibly be on the chopping block anytime.
So what is effective advocacy when we're talking about this? Like, is it an attorney coming up and telling them how important this is? Or is it the legislature talking to each other about this? I mean, what really drives the legislature to keep funding these programs, especially with term limits where they keep changing over and over again?
The families. The families are the ones that started this, that ended up getting the Lanterman Act written, and it's the family stories that we are trying to teach people to tell. Sometimes they need the assistance of an attorney or a fiduciary to be able to explain what the needs are for an individual with developmental disabilities. But I think the families are the ones that are always going to be in the lead, telling the story and making sure that everyone understands that people with disabilities deserve the right to live where they want to live, to have a job, to choose to be where they need to be with the services they need. And there should not be any debate about that. So when they start chopping away at some of our services, what part of your life are you willing to give up?
So I have been a student of deinstitutionalization my entire life. I have seen programs come and I have seen programs go, and yet the Lanterman system keeps going and going and going. But it's all about advocacy here. And so just to put this in a framework, I think we all have a role here. If you're a family member, a person with an intellectual or developmental disability, it's absolutely essential that you are constantly telling your story to the legislature and holding them accountable. For professionals out there, my belief is that we do owe something to our community. And so our hope is through these programs, as we're doing this, you're going to have a better understanding of our system, better understanding of our advocacy programs and all of that. And part of that is to be a good facilitator of information to preserve this system. Not that it doesn't have its problems here, because without it, in most states, there's nothing like this.
In all states, except California, there is nothing like this.
Now, to the core of the program here, which is the IPP process here. This next video, which once again, these are all meant to stand on their own, is we have two interesting characters that are going to talk to us about the IPP and the IPP process here. How important is that?
Well, it is huge. We're now getting into the nitty-gritty of how you write an IPP. The IPP is the individual program plan. It is the document that we end up moving forward to implement. The ARC has a mission to make sure that every person with IDD in the state of California receives the services that they need and deserve, and be as independent as they can be and choose to be. And it's this advocacy that this program is trying to teach family members, attorneys. We're also trying to recruit people that are interested in doing this, because this work, even though the way the Lanterman Act is written, there are ways to correct the wrongs that are done or some of the errors that don't get implemented. There are ways to make it work, but there are times when we need an attorney. And I think family members need to know where to turn. And they are few and far between in the state of California, I'll have to tell you. And it is important that we recruit these advocates to work with the families to learn how to make our stories told correctly so that we know how we can get the services that we deserve. And this session that we're going through with my husband and myself have been advocates for a very long time. And this session covers the basics of how to write an IPP. And it directs, so it gives a few of the little known assists that we need on how to get through some of the trickier parts. We are a very diverse community, and it's important to know how you can negotiate the system when you might not speak the same language as the service coordinator. You might not have the same educational background as some of the people that have are trying to tell you can or cannot have services. It's very important that you know the nuts and bolts of this system. And so that's what we're going to show you for the next half hour or so. Thanks, Steve. And thanks, Chad, for that summary of the history of the Lanterman Act. My name is Pat Hornbecker, and this is
Tim, both parents of a son with developmental disabilities.
Joseph has Angelman syndrome. He's 41 years old. So I've been working with these services for a very long time. And it's important for families to understand this, and that's why we're doing it. Today we're here to talk about the entitlement called the Lanterman Act and the IPP process, how to write it, how to get it, how to fight it, how to make it successful. So let's start with the entitlement. The entitlement is unique to California in that it is a right for people with developmental disabilities to be provided the services and supports that they need. It is also an obligation of the state to provide these services. This is a promise. This is a contract with the people with disabilities in the state of California and their families to make sure that they get the services they need. Now, to do this, you actually have to know some of the players in this team. There are the people with disabilities and their families. There are regional centers across the state, and there is the Department of Developmental Services in Sacramento. There are also lots of providers across the state that help provide these services, and we'll show you how they factor in to this process as we go through. But remember, California is the only state that has this entitlement, this promise to people with disabilities. The IPP, which is the individual program plan, is very important because it's a document. It is a legal document that guarantees the services you should be receiving. It is through this IPP process that the rights of this act are granted to the individuals with developmental disabilities. And then California and the Department of Developmental Services is obliged to implement this plan. So the process itself defines the services. And we do this through meetings. And usually at the regional center, now we do everything by Zoom. So a regional center is in your area. There are 21 regional centers across the state. And I work with Golden Gate Regional Center in the San Francisco Bay Area. Regional centers assess needs, and they lead the IPP process, and they deliver services, sometimes in-house and sometimes through vendors, also through a number of other ways, which we'll get into when we get into the nitty-gritty of actually how to write an IPP. Parents and consumers can be involved in the local regional centers because they are a nonprofit with boards, and they often have parents and consumers who are involved in their boards. The trick of the IPP and writing the IPP is making sure you get all of the services you need into that document that we're talking about. To write an IPP, you need a planning team. The planning team is made up of the individual with disabilities and the family members or legal guardian, a conservator, if there is one legally assigned, an authorized representative, which we'll talk about later, as well as your service coordinator at your local regional center. He or she is a service coordinator, a social worker who is assigned to your case. They have a lot of cases that they're dealing with, so get to know your social worker. Find out if she knows anything about the disability that your son or daughter may have. Joseph has Angelman syndrome. It's not as prevalent as some other disabilities, but don't assume that they understand what you're talking about your son's disability. It's important to get to know them, see if they're culturally competent in your language or your culture, and understand what your needs might be as a family member or as an individual with disabilities. Again, I can't stress strongly enough that if you do not get a service written into the IPP, it will not happen. So when you have the IPP meeting, make sure that these conversations that go on for possibly a couple of hours, at the end result of the discussion is to get the service written into the IPP. Now, we're talking about services. There's 255 coded services give or take, in the Welfare and Institutions Code for people with disabilities. And we have a handout here that gives you a summary of the kinds of services. But I'd like you to understand that this is just a suggestion of the kinds of services you may need. You need to understand that you are choosing a service because it's directed toward the alleviation of a developmental disability, or it is directed toward the social, personal, economic, or physical remediation or rehabilitation of a particular service, of a particular disability, excuse me, or towards the maintenance and achieving of independence and a productive normal life. So this is why you are going to select a particular service to be delivered through your IPP. And one of the things that we also have learned over the years is that each regional center is different. They are independent nonprofits. So if you go from San Francisco to Fresno, let's say, you are going to possibly experience a difference in the policies on the delivery of some of these systems. It is these POS, which is a purchase of service policy, can vary, but have to be okayed by the Department of Developmental Services. It's a compliance check from DDS to check on how regional centers are actually delivering services. You can experience the difference, but if you are experiencing refusals of services that are authorized by the Department of Developmental Services, you need to understand why. And so if you don't understand why this service is being refused or is being modified in a way that's unsatisfactory, request the authority upon which they are making this decision. They have to have received a letter from the Department of Developmental Services that most likely refers to Title II or Title 17. Just ask them, what's the authority? It'll be a letter that they have on file at the regional center that'll tell you why they are able to refuse a service or do it differently than they were doing it in San Francisco.
This next section of the Welfare and Institutions Code is all about choice. Persons with developmental disabilities shall have the right to choose everything that they need for their own life. That could be, for example, with whom they live, where they live, their employment, their leisure time, job training, as well as just an internship. So those have to be taken into consideration. They can be summed up again in personal choices, person-centered planning, which you've heard so much about, and just nothing about me without me. The rights of individuals with developmental disabilities shall include choices made by consumers. So it's all about the consumer, or the participants, are the term we use, and making their choice. No pre-written IPPs. This happens occasionally where you will receive an IPP that's pre-written. You just can say, no, I will not accept that. IPPs have to be a combination of your decisions, your choices, as well as approved by the regional center. But you just can't get a pre-written IPP. So they must respect, most importantly, the values of the person with developmental disabilities. Public and private agencies like the regional center or the providers shall provide consumers with relevant information to help you understand your choices. What do you want? I don't know. What's available? And so often when these questions are asked, you think of maybe one or two services. And as we said, there are 255 services. Those services actually are explained in 80 pages of PDFs. So you don't have to read all those, but you want to definitely be familiar with those services so that you can see which services will be good for you, or you as an individual, or for your parents and guardians and legal representatives. So it's very important that your case manager or your services coordinator has somebody there that can explain these services to you if English is not your first language. So, for example, Mandarin, Tagalog, Spanish, English, those languages have to be in explaining these services to you. In the regional center's website, they actually have these services in your various languages. So really be concerned about those languages. One thing that I want to also take into consideration is the person with a developmental disability, whether they need a communication device, whether they need the information in Braille. First and foremost, it's the choice of that individual with developmental disabilities. And I just wanted to also add the need for cultural competency. And I say that because in some situations, and especially in some cultures, finding a job isn't the most important thing. You have families that take care of their grandmother, they take care of their aunt and uncle. It's really an extended family, and they're very, very close-knit. So they may want more respite than maybe a job placement in the community. So you have to be aware of the cultural diversity of those particular people. I use an example that when I was working in the Coachella Valley, I had a consumer, and the family that she was with was very reluctant to have her work in the community. Well, I was getting funding for the regional center to have her work in the community, but I didn't have funding for any other service or any other supports. So if I was going to get her a job, which I did at the hotel, the local hotel, and she was very, very good, even though she was deaf, she was very good at working the machine called a mangle. Now, if nothing else that you get out of this presentation is you'll learn what a mangle is. But she could iron more sheets in that large mangle that you just stick sheets through when you're working at a hotel, and they come out the other end. But guess what? In order to get her that job, I had to get her Aunt Tia a job, too. That's how her parents felt comfortable with her going out in the community. Now, we didn't get paid for that, but those are some of the differences that you have to take into consideration when you're working with people from different cultures. You have the right to a designated representative. Now, who is that? It can be a parent, a family member, or a friend. But notices need to be sent to those designated relatives, designated representatives, who could be a relative, as well as other family members, guardian, or conservators. Notices need to be sent to those representatives. Why would you want a representative? That's a big question that comes out. Well, another person can hear or witness as well as just you. So when the regional center is saying, well, we never offered that choice, and you have that witness, that representative that's with you, you have right then and there, you say, oh, no, we both heard that. So it's very good to have a witness. And sometimes that witness may be somebody, if you need a translator. So take those into consideration when you're looking for people to be your representative. A sample letter is attached. And in that sample letter, I sort of emphasize that it's not just the meeting that has to be, you have to be notified of. These notices have to go out if there is other locations, phone calls, verbal meetings. So it's not just a meeting in person. The regional center must be given a written notification of any permanent changes and an assigned service coordinator. And this is very important. They have to give you that notice in 10 days. I've had situations where it's been 3 days, maybe 5 days, and all of a sudden you find out that you have another service coordinator. That's not enough time for you. That 10 days before your next meeting, you need to have somebody be telling you that you have a new service coordinator. And then at that meeting, you can either choose to accept that person or not to accept that person.
And the service coordinators are someone you need to get to know, as I said, which is why you get assigned 10 days before you're supposed to be notified. I have had many social workers assigned to us, but I think I've had some for 10 years. And then I've had 3 this year. So having 3 different social workers makes it difficult for someone to get in touch with your history and the services you received and what changes might be necessary in the next phase of your life. So this is why we come to writing these individual program plans. What are the needs and preferences? And the law stipulates that you must respect and adhere to the needs and preferences of the individual with developmental disabilities. It's all about person-centered planning. The plan is written around the individual with disabilities. And it does involve the family at times when there's family burnout. Oftentimes respite is a reason services are given to families because the individual with disabilities is has very intense needs, and there are other siblings in the family, and so having respite is very important. In-home respite, out-of-home respite, but it's important to take account the needs and preferences of the individual. The purposes of some of the goals and objectives that are being written are written for to promote community integration and independence, to gain a productive and normal life with stable health and healthy environments. It's really, really important that is why we are choosing these. We're not choosing these services just willy-nilly. So this is an important understanding necessary for the person-centered plan to be written. The writing of the IPP is very interesting. You need to write a number of goals and objectives. That's the first thing. What is a sample of some goals? And if you've been in the school system, you probably have written goals in your IEP, Individual Education Plan. And if you have those goals, we're looking at similar goals probably at a more adult life, or even during the years while you're in school. You're looking at needs that the family and you need to support you in your independence. Some of these goals might be eating independently. It could be sleeping through the night, walking home from program, taking the bus to and from program, exercising regularly, shopping for meals. Those are examples of the kinds of goals you might have in an IPP. Then you're going to figure out who is going to provide these services. Well, these services can be provided by contract providers. If you were needing a behavioral plan written, you can have a contract provider. You can have a vendor like the ARC. We use the ARC of San Francisco, provides a lot of the vendorized services for my son Joseph. There's generic services that are used. A generic service would be something that's usually available to the general public. Something like Muni, getting a Clipper card, or having a membership to the local YMCA. Those are the kinds of things that we would often use for a generic service. There's also natural supports. Now, what are natural supports and why would you write them into the IPP? A natural support would be, well, when Joseph gets home from program, grandma's at my house. They're covering the gap of time between the end of the program day and when I get home from work, which could be 3 or 4 hours. That's a natural support. It's not paid for by the regional center, but it's something that needs to be put into the IPP. Sometimes, as one of the goals was to shop for meals. Well, on the way home from program, Joseph stops at the local grocery store and he gives his list of shopping items to the grocer. This grocer has been on this corner for 20 years, and it's someone who knows Joseph, watched him grow up. He's going to take that list, help him fill the list out, pay for it, and send him on his way. Now, that's a natural support. It's not something that's paid for by the regional center. Why would they care? That has to be written into your IPP. It's a way of achieving your goals. It's a way of supporting. It's an important idea so that if it goes away, if the grocer goes away, if grandma passes away, these are supports that need to be replaced. And having that in your IPP may seem like a small detail, but it's actually very important to the overall success of the IPP. There also would be The IEP I've mentioned before is important because while you're going through your school years, you have an individual education plan. Well, if you're a client of the regional center from age 3 or so on, you also have an IPP. And oftentimes we have found out that a lot of families don't realize that they have an IPP and an IEP. So in that situation, I would make sure that you take your IEP and attach it to your IPP. And if you are the person sitting in the boat where you have an IEP, you should have an IPP and you don't know what it is, you've probably been receiving one of those pre-written IPPs. So beware and find out how you can get a hold of the IPP and figure out how you can have a meeting. Call a meeting. They have to hold one in 30 days. And then you can combine both of these documents and make sure that they understand that you understand what your rights are. In the IPP, there has to be a start date and a timeline of when these goals and objectives are going to be achieved, when they're going to start, when they're going to end. Most IPPs are reviewed every year. You can review them more recently. The law says that you have to do it within 30 days. So the regulations, if you call your social worker and say, I need to have an IPP because this has happened in our lives and we need to adjust some of these goals. Joseph's been sick, or I've been sick, or something has come up, so we need a new IPP. Then they have to hold it within 30 days. The start date would be the start date of when the services are going to start. Let's say we write the IPP today and we're going to say that everything starts tomorrow. Or we're going to say that 6 of the 10 goals can start today, but the service for music therapy can't start right now because we don't know who's going to provide it. We don't have a vendor. We don't have a contract provider. Who's going to do that? Well, then you write into the IPP that we're going to give 30 days for the regional center to find that vendor and find that individual, find whoever is going to provide that service, and then provide the service. If that doesn't happen within that timeline, that's going to trigger us to hold another meeting. So those are the timelines that are really important. And again, if you need an IPP at any time because something has changed, then you can call it and it will prompt the meeting within 30 days. This is a jointly planned meeting. We're working together as a team. It's the individual with disabilities, their parent, family member, their legal guardian, their conservator, and the social worker representing the regional center. We all have to be in agreement. To do that, all of that needs to be decided at the meeting. It's important to know that the people at this meeting can make this decision. The decisions are made here by the social worker and you as a team. There is no veto power and there is no committee down the hall that's going to be deciding the services. You need to make sure that you have the conversation, you write it into the IPP, and that is the end of that discussion. But make sure after the discussion, it did get written into the IPP. The final agreement that we come to may not be everything you wanted. So if there's one service that's debated, we agreed on everything except music therapy for just the one I'm picking out, then you need to be able to the regional center must hold a meeting within 15 days of this meeting. So before you go to your IPP, pull out your calendar and look for a date, 2 weeks, 15 days hence, that you are willing to come to a meeting. You can make it longer. They can't make it longer. You can hold the meeting in a month if you choose to. However, if the regional center is going to meet your needs for this debated service, then you need to make sure that that meeting is held within 15 days. So that is their obligation. Then if you don't agree with some of these services, then there is a possibility of triggering the fair hearing process. You need to understand
that fair hearing is your recourse to the disagreement on the service that's being debated. So you have the next meeting in 15 days and you still don't agree, but you think that this service is something that's necessary for your child to be successful and promote his or her independence. This fair hearing sounds threatening. It sounds legal. It sounds upsetting to a lot of family members, but it is a process that can be handled with an informal meeting. It can be handled with mediation, where an independent person is assigned to the particular case to listen to both sides of the discussion about receiving the music therapy or respite or transportation. And then they will decide what's going to move forward. And then there is, of course, the going to court, which is a possibility, but very few cases actually go there. You can go to your own to the website of the Department of Developmental Services, which is dds.ca.gov, and they will provide you with data on the fair hearing. Just click on fair hearing. It'll give you the right forms you need. It'll tell you what your rights are in the process and give you the timeline. I'm going to review some of that right now. But understand that the fair hearing process is specifically about a disagreement about services. And that's important to understand, so that if you decide that you are arguing about the service, you're calling for another meeting, or you're just filing for a fair hearing. If you have all the services that written into your IPP, and in the course of the next few months, you realize, well, by the way, transportation has stopped. I don't get a bus anymore for my son to go to program. What's happened? And the regional center has stopped delivering the transportation service. Well, that doesn't make sense. You should have received a notice. And there's a proposed notice of proposed plan, a proposed action, which is oftentimes it's 1803, I think, is the number of the form, and we have it here on our slides to reference that the regional center should be notifying you if you've changed your transportation. Let's say they're changing from transportation to program to no transportation at all. You don't have to accept that. You've agreed to it at the meeting. They're unilaterally changing a service. So what you're going to do is take the form, you're going to sign it at the bottom and return it objecting, saying, I object to this proposed plan of action, and you're returning it within 10 days. You have to look at the bottom of this form, and it is very small print, but it says you have to return this within 10 days, at which point then the transportation that you've had thus far must stay. It is what I call the stay put provision. It's the way you get to keep your services while the debated service is disputed. So it's important that you send this form. Now, if you're using snail mail, you want to make sure that you're sending it in certified first class mail with a return receipt. If you're emailing it, you're copying everyone that's on your team, your client's rights advocate, your social worker, and you're sending it to the director of the regional center. You can find that name, rank, and serial number usually on the notice of planned action, but you're also going to find it on the website of your regional center. This letter you need to save the letter. You also need to save the envelope that you got the letter in if you received the notice of proposed action, because that will have the postmark date on it. The notice of proposed action may have an entirely different date and written 2 weeks beforehand. Remember, they need to have given you notice about this plan of action, and you're responding to when you received the notice, not when the notice was actually written. So that's tricky, but it's a very non-threatening way of you to respond to a form you got in the mail, very simply. So we want to make sure that the debated service keeps on trucking while we're debating it. And it will, if as long as you respond to the notice or send in your fair hearing request. Those are the most important things you need to do.
You've been explained about IPPs, about fair hearings, the right to have a designated representative. Well, there's another right that you have, and you have a right to electronically record your IPP meetings. You have the right as a consumer or a parent, legal guardian, or conservator. No permission is required. You do have to notify the regional center 24 hours in advance of the meeting, but when you notify them, it's good forever. So any subsequent meeting, you don't have to give that notice, that 24-hour notice. They're automatically going to receive that. Now, why record? Well, the same reason that you would have a designated representative. 2 videos are better than 1. And once you decide that you would like that recording, you can have the regional center automatically has the right to likewise record. So 2 recordings probably are better than 1. So when you go back, you not only have that representative, but you have 2 recordings to verify the services that you were told that you would receive. So the permission is all in your hands. You have the veto power in the hands of the consumer. However, like I mentioned, the RCD, the regional center, can also record if you've approved that. They don't need permission, but not a bad idea for you to have both recordings so that you have that information to back up what either you've asked for or what they've decided to give to you. There is a form that when you want to have a recording, and you need to put that in this notice that the letter is written, the notification in advance. And again, it's about conversations, telephone calls, or authorizations of services. It's not just the meeting that you have. It's also those phone calls or those verbal agreements that you've made over the phone. So those can all be recorded.
Make sure you copy your client's rights advocate at the regional center when you are requesting the electronic version of a meeting.
Now, the DDS IPP manual says that the regional center must have a decision maker at your IPP meeting. So it's not just in the Welfare and Institution Code, but it's in the DDS IPP manual too. Who knew? The quote from the DS manual is so important. It says real-time decisions. So how do you know if a real-time decision maker is there, a person who's authorized to make that decision at that meeting? Well, is somebody here who can authorize my services? A simple question. And if no is the answer, and especially, and I've had this happen, well, I have to go to my supervisor. I'll get back to you. Stop the meeting right there and say, no, I won't have another meeting unless there is an authorized designated person. That's a real-time decision made at the meetings. A very controversial and discussed section of the Welfare and Institution Code is about the cost of services. It says that the cost of services of supports of comparable quality shall be reviewed and the least costly shall be selected. Now, what least costly, you would think, okay, right away, I don't have a choice in that. You do have a choice in that, especially when they added the term comparable quality. I'd like to sort of summarize this, but please read this section carefully in entirety. Basically, comparable is the key word. How is comparable determined? Ask for an analysis. Ask who's authorizing this. Ask for a quality review. There could be more than one provider, and they're going to say you need to go to provider 2 instead of provider 1 because they're more expensive. Well, the key here is that you have to make sure that it's least costly if it will result in moving the consumer from the existing provider to that provider number 2, but not if it's a more restrictive or less integrated services or supports. That's the key. So they can't automatically move just to a less costly program. It has to make sure that it's not any more restrictive or less integrated as the services you're already getting.
The least restrictive environment. You've had deal with that through the education system, and we do the same here through the IPP process. When you're selecting a service, it must be what's appropriate for the individual and not just because it's cheaper. So that is a discussion that usually happens at the IPP when you're debating who the service providers are going to be. When you are calling for meetings and they never hold a meeting, you made your request and 30 days later, there's no meeting scheduled. 60 days later, there's no meeting scheduled. That's a violation of your rights and the rights of your son or daughter. It's also the initiating process for complaints. A complaint versus the fair hearing process is important to understand. A complaint is not you just whining about something. A complaint is a violation of rights. They didn't hold your meeting when you requested it. They did not recognize my designated representative. They did not allow me to record my meeting. They did not meet the timelines that they were supposed to meet. You're not debating a service. You're not debating where the service is being given. You are debating the rights of the individual. Those rights have been violated. And that is also found, it's triggered by just sending a form. Again, you can go to the website of the Department of Developmental Services, dds.ca.gov, and type in complaint in the search role, and you will find that this form comes out. And download the form and send it in. And all you have to do is put name, rank, and serial number in the form and what your complaint is. They didn't host the meeting. They didn't recognize my desire to record the meeting. And that's a violation of your rights. That will trigger some timelines. You're sending this to the director of the regional center, and you're going to copy the client's right advocate and your social worker and whoever else is on your team, parents, family, a designated representative. This form simply will state what the violation is, and then you send that on to the regional center. And what you'll find is that the director of regional center now has 20 working days, those 20 working days to investigate the violation of the right and determine a resolution to solve it. Well, host the meeting, recognize the person, whatever the rights are being violated. Hopefully that director of the regional center is going to be able to provide the resolution. That resolution will be sent to you by mail in order to, with a name, rank, and serial number of who you're supposed to respond to. If you do not respond, that resolution will go into effect. If you do respond and don't like it, you think this is not the right resolution to your debate, then that takes it up to the next level. And it goes up to the Director of Developmental Services. You go up there, and now that person has 45 days to come to a resolution of the debated right that's been violated. This correspondence, again, I have to tell you to keep records of it. If you're doing anything by mail, make sure you make copies of what you've received and what you're sending off, and save all the postmarks on the envelopes. These timelines are important, and it's important that you be able to understand when and where certain things are supposed to be happening. If the solution is not satisfactory, then you are moving it up to the next level. If you don't answer it within the 20 days at all, then the resolution will go forward as already proposed. And why would you file these complaints or fair hearings? A lot of people find it very intimidating, but it's valuable to the entire system. As advocates, we want to know what's wrong with the system so that we can continue to maintain the entitlement as it exists. and strengthen it, find the holes that are in our system. And we will find that by understanding what services are continuing to be denied to people with disabilities across the state. Is it only in rural areas or urban areas that we're finding an increased difference in the delivery of services? Are we finding that certain rights are being violated through the complaint process? And if you go to the website, you can actually go and click on all the fair hearings that have been held, and you'll see how many have been held with regard to certain kinds of services, the delivery of respite or the lack of delivery of respite, because that's usually what the debate's been about. You'll find that there's a lot of debate in the compliance issues, usually on the timelines of hosting meetings. Many of them you'll also find how easily they're resolved. They're easily resolved with that letter. And that's why it's important that you continue to fight to keep the entitlement as strong as it is. And it only will stay this strong if, in fact, we continue to fight for our rights. So don't be afraid of the complaint process or the fair hearing process. It is usually something you're going to seek support. And there are people, advocates out there, there are attorneys, there are lots of providers of services that are willing to advocate with you to make sure that your rights are upheld under the Lanterman Act.
The Lanterman Act and its promise will only survive if family members like you, friends and consumers, are vigilant and service and active. And I say this because, as you've been previously explained, it's all about parents getting together. For example, that's where the Lanterman Act came from. It was legislator Frank Lanterman who was sort of confronted in an elevator. And finally, after writing the Lanterman Act, he finally got it approved by President Reagan, and we have those services to this day. But we must hold those same legislators and our current legislators accountable. We need to pressure, protect, and expand services. And by that I mean, if there's more respite needed, and there's only so much allowed at this given time, there was none, it was like 20 hours a month, you need to ask for more of those. We maybe need to change legislation so more is approved by the regional centers. We need to organize your people with disabilities, family members, and friends to have a voice and to tell your stories. You need to be able to tell the impact of what those services mean to you by what's your son or daughter, or you in particular, are receiving, or what you're not receiving. Those stories need to be told if we're going to continue the Lanterman Act. More voices equal more power and influence. So I just have, I wanted to share with you that, I went to a legislator. I asked that legislator with a family member, a mom, and with her daughter with disabilities. And I asked that legislator, please don't cut $200 million from the state budget for people with developmental disabilities. We asked him, we spoke to him. He said, oh, sure, we won't let that happen. How do you think that worked out? They only cut $175 million. What would have happened, I had to ask myself, if instead of that one parent and that one daughter with developmental disabilities, I had 200 other parents and people with disabilities in the hallway? Would have definitely had a greater impact. So you need to tell your stories, but you need to get other people to tell their stories too, if we want to have influence and power. Work with other disability groups as well, senior groups, other disability groups, transportation groups, people trying to get transportation that have disabilities. Work with them all so that we have a bigger clout, more power. There are 800,000 people with developmental disabilities in the United States that are still on waiting lists for services. 200 in the state of Texas alone, 200,000. So we are the only state with this entitlement to services because of the Lanterman Act. Help us keep it.
I want to thank you so much. And I always learn something new every time I listen to this. Now, I just have a few questions. The first off is you talked a little bit about the right to attend here, the IPP and the designated representative. Can you go into a little bit more about, maybe specifically for parents, when is it appropriate for a parent to attend and when is it inappropriate for a parent to attend?
Well, I think it's appropriate for a person to attend, a parent or actually any designated representative. If the person is not conserved, that person with developmental disabilities has the choice whether a parent is there or not. They have a decision. But if they are conserved, if they have the family member designated representative who could be a conservator as well, if that's the case, that person with developmental disabilities has the decision on who comes to their meeting. If the person is conserved, then the designated representative could be the parent. They have the right to attend.
But the person with disabilities can say, I don't want mom there if they're not conserved, correct?
Right.
Okay.
So
That's
it's really all about consumer choice,
Right.
right? And that's what we're doing, is we're talking about focusing on the choice of the individual.
Mm-hmm. Absolutely.
Terrific. You also talked in here a little bit about the client's rights advocate. Who is this client's rights advocate and where would you find this character?
Well, every regional center is supposed to have a client's rights advocate on staff. And that is someone who would be supporting you as a consumer and as a family member to negotiate the fair hearing process and the complaint process, or any questions you might have outside of the IPP meeting that might involve some of those parties in particular. But I don't know if they're all occupied by someone. However, I would go to my director of the regional center, I'd go to the website and I would research it. But there should be a paid position at each regional center for a client's rights advocate.
Terrific. Here's my last question. And we're recording this here the summer of 2022, here hopefully at the end of the pandemic, but we'll yet to see. But some vendors are having a real difficult time here providing staff for services, and the turnover is at an all-time high. What does an advocate do if, for instance, the services aren't being provided because of staffing issues?
Well, regardless of staffing issues, the need and the IPP has been written and validated and signed off, so the service has to be provided. So I will advocate for the fair hearing process and for the complaint process. It needs to be documented. Data talks. The data makes a difference at the state level. It makes a difference across each of the regional centers. We'll find the disparity of the staffing, and it's the only thing that's going to possibly push the legislature to actually understand that higher rates need to be authorized, that better salaries need to be authorized in order to attract the staff that is necessary to take care of our services.
And having been an executive director of over 3 programs, I can tell you for sure that it's extremely difficult in this day and age in 2022 to find staffing. The range of salaries has gone everywhere from $15 to now you can't hire anybody even at $18 an hour. So we really need, as Pat said, to get more funding for the salaries of these people if we want to find more people that can offer the services to our sons or daughters, people with disabilities.
And please remember that families and people with disabilities is what made the Lanterman Act happen. The ARC made this happen. Tim and I have worked with the ARC of California for over 35, 40 years, and it's an organization whose mission is to ensure that this Lanterman Act, that the promise of the Lanterman Act survives and is strengthened. And there's 21 chapters of the ARC across the state. It's important that they be involved in your concerns. So reach out to your chapters of the ARC. Reach out to your family resource centers. Reach out to the different groups that are supporting our mission to make sure that people understand their rights, understand the process, understand how to make it work for them, and maintain this entitlement. We want the Lanterman promise to be a promise forever. Thank you.
Thank you.
Anyway, Pat, it's kind of interesting dealing with the virtual Pat and the real. This apparently is the real Pat here. But thank you for getting so involved with this. Just a couple of things before we get into questions and answers and that sort of thing. Part of, I think, the importance of this particular segment is that with the entitlement, it's really important that families and persons with disabilities understand that entitlement, because otherwise, if you don't understand the process, then we're not going to get the full scope of value out of the Lanterman Act. Any thoughts on that?
Well, if you don't understand the rules of the game, you can't win. And I think that we need to understand how the Lanterman Act came to being, and it was through families and family stories. And I think if you start sharing your stories, apparently I was closing at the previous video speaking about joining the ARC, being in touch with the right people that have the information and the resources that'll help you understand what the roadmap is to gaining success and building a successful life. So go to the ARC California website, thearc.org, read the Monday morning memo, sign up and get all of our action alerts so you know that when our system is being threatened, those are things that we need to act on, and that we are acting on, as the ARC are acting on behalf of all the family members across the state, family resource centers across the state, and family empowerment centers are also resources. So if you reach out to your regional center, sometimes they can be a helpful resource. And that is asking the questions and continuing to ask the questions is probably what will unite families. I think also we need to remember that everyone can be an advocate. You don't have to be an attorney. And if you have to use the due process or complaint process, you don't need to be an attorney. You can find someone who's a trained advocate. I mean, I've represented other families. I've gone to IEPs and IPPs, and I've helped other families know the system and understand their rights. And that's why we're creating this seminar, so that people understand what they can do in their own world, right?
Absolutely. So, in closing this, and as I like to say, we're going to get to the most terrifying part of the program. Let me start off with introducing Amy Tessler. For those of you who don't know who Amy is our Education and Outreach Coordinator for the Golden State Pool Trust here. And Amy, the question is going to be, do we have any questions? But before we do that, what's your involvement with the Lanterman Act? Is this something that affects your life?
Well, I'm the parent of a 27-year-old with autism, and I didn't know that all these entitlements that I had were unique to California for quite a long time. So it's really important to me to make sure that all these entitlements stay here in California, so my son is well taken care of for the rest of his life. So I am very involved in advocacy and following what's going on with respect to bills. And I find that the Monday morning memo is very helpful, and it makes it really easy to sign on to petitions and get on letters and phone calls that really make a difference. Because if we don't all speak together in one voice, nothing's going to happen. So I find the Monday morning memo being one of the best vehicles for advocacy.
Good. Now, do we have any questions?
So the first question, did the Supreme Court limit DDS oversight of the regional centers?
Curious question. I don't think it limited oversight, but maybe it would be good to talk for a minute about what is DDS's role in this. In fact, what is DDS?
Well, the Department of Developmental Services actually has oversight over the regional centers, and DDS has the policies on how the IPP is to be written and the services that are to be delivered. So each regional center then also has its own POS policies and regional center policies, which may differ from regional center to regional center. However, as they are changed, as I mentioned earlier, they have to be sent, those changes have to be sent to DDS in Sacramento in order to be approved. That process is a little bit more of a mystery to me, but it is the way it's supposed to happen.
So they do have a role. A lot of this is, driven by the regional centers. And you might keep in mind that before the Lanterman Act, it was the Department of Mental Health, and everything was run by the state. And this is part of the whole objective of the Lanterman Act, is to bring that to nonprofits. Each of these are nonprofits. We're going to learn that in the next program coming up in part 2. But these are nonprofits and here. And so a lot of what DDS does is helps make sure that they're on track, make sure that, they meet their contracts, that the money flows, and they do have a say when it comes to policy.
Okay. Are the legislatures aware of how clients are being left without day programs and other services? My son, this person said that he is not being supported because he needs one-to-one supports and the staffing is just not there. So question 1 is, do our legislatures know that this is happening? And number 2 is, what can I do to help the process along to get more staffing?
Well, they don't know if you haven't told them. So do you know who your legislator is in your area? Do you know where their office is? Do you know how to reach them? Do you know their email? Do you follow them on Facebook or Twitter? Those are ways you can be in contact. As far as how they may or may not vote on issues relative to people with disabilities, that data is probably harder to dig into. But no, I don't think they know offhand that your son is sitting at home. On the other hand, how do you tell? The second question was about, so how do I let them know? Well, you reach out to them and you tell them what's going on. Day programs and the changes that have gone on in the last 3 years have mostly gone on because of COVID and the COVID restrictions that we've had. So some of them are building back up and going full bore, hopefully by the end of this year. And some are not. It varies from county to county, to regional center to regional center. So I would be in communication with other regional centers to see what they're doing, or other service providers as well, because there's more than one service provider in your area, and you might want to look at different ones.
I think a lot of the key is, especially because a lot of this is legislatively driven, and we'll probably talk about this more later, but I am actually on the policy committee here with the ARC, along with a number of different folks. And a lot of it is a matter of constantly educating legislators, which you can do at the local level. They do listen. Here you can do that, at the state level, whatever. Now, one of the ways we do this, Pat, is we've got this thing called the policy conference. Does that?
The ARC of California has had 16 years. We're going into our 16th year of a disability policy conference. And this year, our disability Community Advocacy Conference is going to be held in March 25, 6, and 7. And it's a virtual conference. And we try to educate our families and advocates or wannabe advocates on what are the issues that are hot on the presses that we need to be focused on as the budget goes through its budget process, as legislation is going through its process, and bills we should fight, those we should support, why, and have all of those discussions. So again, if you're join the ARC of California and your local ARC, you're going to find out about some of the opportunities that are going to be made available to you to educate yourself.
So it's a whole system of advocacy that's necessary. And I have to tell you, when you compare it to other programs and that sort of thing, I think that's one of the reasons why the Lanterman system has been comparatively so successful compared to other programs. It doesn't happen on its own.
I think many were really surprised with the services list that you provided, and that is also included in the materials that were sent to you as handout 1, so you can see that in more detail. But the question was, I never knew the regional center could actually pay for music therapy. Will they really, really do this?
Yes, my son had music therapy for 10 years. And the music therapist came to my house once a week for 10 years. He had moved out into his own apartment somewhere along the way, and so the music therapist went to his apartment. The problem with some of these services is who's vendored, who's not vendored. They don't pay great. So to be vendored as a service provider, you're a music therapist, I think the going rate at the time, and mind you, this was a while back, was $40 an hour. Now, $40 an hour is probably not much for a music therapist if you were going to go find one. So when you find the list and you say, oh, I'd like equestrian therapy, or I'd like whatever is on that list that you think, it's not really a wish list. You do have to validate why you're having the service and what benefits you expect to achieve. And then the vendoring process is undertaken. Sometimes they have them. Behaviorists are often on staff already, and those are probably also underpaid, but they're usually more readily available. So yes, they paid for music therapy for 10 years.
And just to echo on something you just said, that I learned that it's really important to have strong goals in your IPP. Like you don't want to go in and say, I want music therapy. You need to have a goal that supports music therapy. There has to be an outcome that's going to be achieved by having that service. So it's the goals that are really important in order to get the services. Next question. With respect to an IPP, if the group cannot agree at the meeting, there was one of your slides said that within 15 calendar days, there must be another meeting. And the question is that calendar? It didn't say. Is it calendar days or is it business days?
Calendar days.
Oh, okay. So it's calendar days. All right. Now, the next question might be more up Steve's alley, but in due process, attorneys can be awarded. In fair hearings, they cannot be. And because of this, it's really hard to find attorneys who will represent participants. Is there a possibility of changing this? And if so, how would you recommend us doing that?
Well, let's see. If there were a possibility here, and Pat, you could help me with this a little bit if you could. The Lanterman Act didn't come from a bunch of attorneys. It didn't even come from a bunch of employees who thought, well, this is how it should be. It came from families and persons with disabilities. Now, I would say if a legal group came and tried to advocate for this, I think the chance of this is greater than zero, but not much. On the other hand, if there's a true impediment with that, the thing that would move that would be, once again, families and persons with disabilities saying that there is an inequity here because, more and more, sadly, this is supposed to be a system that's based on need, not based on wealth. Right. Sadly, that's not entirely true.
Well, the squeaky wheel gets the oil, and unfortunately, it looks like that often is the case with getting the service. But who needs to be doing the squeak? It is not always an attorney. And that's where advocates need to band together. I think in some cases, if there is enough of a violation of rights or services not being provided that it could be turned into a class action suit, we'd go to Disability Rights California. Their goal is, or their mission is, to be representing people with disabilities and making sure that their services are delivered. And so there are nonprofits that do that. I would work through a number of nonprofit organizations that provide advocacy work. Now my goal is not to get attorneys paid.
Yeah.
So it's not anything I'm against either. It's just about the fact that there are other ways to do it. And advocating to the nth degree before you go to an attorney is probably more beneficial to everyone, because once you establish that attorney-client relationship, then the school district's got an attorney. And that is a really tough road to go, or the regional center. I'm sorry. So either way, it's there are many ways to do that before you have to get there.
This will be one of the things that we will be covering in later programs, but I'll just throw this out, is that part of our objective in presenting these programs is to introduce you to different programs along the line that can assist. So for instance, we have Disability Rights California, we have the state council that sometimes can intervene. We have, all sorts of different groups that have a dog in this race and they want to make sure it runs. It may be just about whether or not it's not just doing the IPP, it's an effective IPP. Let's say you're in a situation where you're not an English speaker and you really don't effectively have your group put together with folks on the regional center side and the service side that are able to communicate with you. With a problem like that, there are different groups like the state council and all that can do that. The other thing that I'll kind of mention as we get into this, there's a theme. I get a lot of people who think the regional center is this monolithic state program, and it actually isn't. These are nonprofit organizations, and I would suggest to families it's a good idea on occasion to go and actually attend a regional center meeting. And guess what? At the very end, by statute, there must be an open period where people could ask questions and make comments. And that oftentimes could be a very good way at the local level to be able to make those changes. If you're having a problem, other people are probably having the same problem.
Yeah, a regional center board meeting is a very interesting, eye-opening experience to know who's running it. Oftentimes, there are family members who are president of their board. They are structured as a nonprofit is, and they have many committees, and it is an eye opener. So it's worthy going to their website, find out. They usually meet monthly, sometimes quarterly, but find out when their meetings are. They're open to the public because they have to have that public input at the end of the meeting.
I think engagement is the key at every level.
Okay. Well, in this day of COVID, many IPP meetings have been held via Zoom. And technically, the law says you're allowed to have a audio recording. Well, in this case, a parent is saying that the regional center refused to permit a video recording of Zoom because only audio is technically allowed. Is that really okay?
Well, you have to understand that when the Lanterman Act was written, there was no Zoom. I mean, there wasn't Zoom until fairly recently.
There wasn't a Twitter.
There wasn't any of that. So taking that into context, I actually think it's possible to audio record only the Zoom meeting. However, if it was me, I would probably write a letter to my service coordinator, the director of the regional center, this client's rights advocate, and the service provider I'm working with, everybody who's involved in the team meeting, saying, due to the circumstances today and 2022, I am requesting permission to not only audio tape it, because you can do it on Zoom, but I'm going to record video record the entire Zoom meeting. And if they decided to say no, I'd probably take it a step higher to find out why. Because they're hiding something, in my mind. If you can audio tape it, then what the heck? I mean, nobody should be worried about showing up in curlers or something.
And I think the other part of this is if you go back and look at the regional center itself and how it's set up. I remember having a talk with Jim Burton, who was our former director of East Bay, Regional Center of the East Bay. And as he pointed out, they're one of the largest organizations in the area. And there's 3 levels of supervision for this program, and he only knows what's put in front of him. So if you don't make it known to the leadership of the regional center, be the board or be it the director or be it a supervisor, they simply don't know that this is even an issue.
Mm-hmm.
And so it's important. It's something you have to participate. Yeah, there's a little bit of democracy going on here. Sometimes it doesn't seem like it, but there is here. And you might be amazed at how responsive you'll find them.
Okay. Pat, you mentioned a website to get fair hearing data. The viewer actually went to that website and said that there were numbers of fair hearings, but not specific data. Where would you get that? How could you get that?
Well, it's still at that same website, but you have to dig a little bit deeper than that. So I would just keep digging. I know that that's the website you start at, and from there you can. You're looking for data. It sounds like the person is looking for data on how many fair hearings there are about a specific service that's not being provided. That's where you'd end up going there. I can't go any deeper. I don't know how I'd explain it on the website. So that's my fault, actually.
Okay. The next question has to do with self-determination. Do you think this is a good program for regional center clients?
Okay, as a parent, I'm going to say no. I do not want more work. And self-determination is a lot more work for me as a mom. It's probably a lot more work for me after I'm dead that I have to leave for everybody else to take care of. I don't want to deal with the changes in services that I will need as my son ages and needs more services, because it's a process as opposed to the evolution of my son's needs being recorded as he goes from 40 to 50 to 60 years old. The changes in a self-determination program is a lot more restrictive. And I actually think you don't get as much money in your budget for your person with disabilities, as opposed, because you have to take some off for the fiduciary responsibilities that you are now in charge of instead of the regional center being in charge of.
I might suggest before that we might take a minute for folks who don't know what self-determination is. Pat, now being nice, what is self-determination?
The person with disabilities has the right to determine their entire program. They give you a bucket of money that is allocated for the services and that you need at this current time. You are required to hire a fiduciary to manage and answer and all the paperwork and dot the I's and cross the T's to show that you're managing it correctly. which is a bureaucratic nightmare for me. I'm sorry, that was an editorial comment, Steve.
That's okay.
But that's where I say, no, that's not my job. I'm not a regional center. I'm going to let the regional center do it.
So, my comment on this is that I think the Lanterman system is something that is constantly evolving. Folks are constantly searching for different answers. I mean, as we all know, the disability community is diverse from person to person and group to group. It'd be a lot easier if they weren't, but they are. I mean, that's the way it is. And so there's different models that folks are looking at. I know I've had parents who like the control over the self-determination and have found that the administrative part isn't that daunting. I've had more parents who have come to me and told me that the administrative part is more than they can handle. I know it's something that's in progress, and it's probably something we'll cover, sometime in the future.
Right.
So, yeah. But there's a lot of evolution going on, and I know we can't spend a lot of time on this, but even one of the future things we'll probably talk about is decision making, and supportive decision making is another model being floated out there. So we're constantly evolving. One, how do we deliver services, and how do we even determine the services? So anyway.
Okay, I think this is probably the last question. There were a few questions about how to find parent advocacy groups. And that's coming in parts 2 and 3. But in the meantime, if you need a specific recommendation, you can email me at amy@gspt.org, and I'll give you some suggestions and give you some guidance on how you can do that. But that will be covered in the next, it's either the next webinar or the third one.
Amy, that is a great setup here for our closing coming up, because the next 2 programs, which will be announced soon, one will be on information and advocacy organizations, and that's going to involve here the ARC, the San Francisco Autism Society, to cover a disability-specific organization, a family resource center. And if you are not involved or familiar with your family resource center, you absolutely should do that here, and the state council. Now, each of those organizations will help you with this and find resources. And, one of the reasons that the regional center system was set up the way it is, because I think regional centers are almost as diverse as the disability community itself. They were created to reflect their communities and their needs, and by design. They have a rough template, but after that, there's a lot of diversity within those organizations. And as far as how these different organizations work, whether you're a family member or a professional or an advocate, or you're just curious here, you want to get to know those local programs, because oftentimes they do provide, and I would say not only assistance, but effective service. I know for myself, in a lot of cases, when I have a parent who's trying to navigate a problem and just needs a little touch of common sense, oftentimes I will refer them to the state council here. And our state council, Sheridan, I hope you're watching this, kid. Here, our state council is very effective. You may find other organizations in different areas. The other thing is a lot of parent groups talk to each other. Amy, I know you're a parent group junkie out there, but a lot of them, other folks have been down this path before here, and oftentimes the resolution in your community could be on one of those listservs. For instance, I have a special interest in Down syndrome, so I'm modestly active on the Silicon Valley Down syndrome network, which I find here is very effective in communication. It kind of brings us back to the Lanterman system. This is something that was created by families and persons with disabilities, saying there's got to be a different way. But the only reason it's still here, quite frankly, is because of the families and the persons with disabilities that are constantly advocating.
Mm-hmm.
And I would guess the minute that stops, we will become like every other state here, where we will have waiting lists, right?
Right. It's not to say that it's a perfect system, but we're miles ahead of any state that doesn't have an entitlement. And we know that anyone who's moved from California to any other state and then moved back has been greatly appreciative of the system that we have and the way we can assess and determine the services, the breadth of the services we provide. It's been our advocacy that closed the state hospitals and opened more community services. It's been families telling their story to every level of government. It's families recruiting attorneys and fiduciaries into their lives saying, let me tell you about my story. Can you help me set up a future for my child?
So, anyway, Pat, I especially want to thank you here, and Tim, who wasn't able to make it today, for your involvement with all this. For those of you who watched Chad's piece, wasn't that incredible? I mean, that really helps to put this in motion. So I want to thank everybody for attending today. And with that, my expectation is that these videos will be available soon. Please feel free to share them far and wide, and stay tuned for part 2, which will be coming up sometime in January, which is on advocacy and information organizations.
Okay.
With that,
Thank you.
Happy advocating. Good night.
Good night.